Number 52661, Stephen Carrigan. Mr. Paris and Ms. Hamilton.
Yes, Wayne Paris here on behalf of Stephen Carrigan over here to my right. Mr. Chairman, members of the board, this is an appeal from a modified judgment of partially probated suspension that was dated on July 16, 2013, consisting of 3 months active with the remainder probated. The judgment contains some findings of fact that were never adduced in evidence in a Rule 2.17L evidentiary hearing. So it is erroneous in that regard. There is no evidence to support the findings of fact in the judgment. In fact, the modified judgment even says, as a finding of fact, that the respondent stipulated to a violation of the rules. That is a legal conclusion, and that is a legal finding. That is not a finding of fact. Rule 2.17L of the Texas Rules of Disciplinary Procedure is entitled Evidentiary Hearings. And in those evidentiary hearings is when the petitioner and the respondents present evidence. Rule 2.18 of the Texas Rules of Disciplinary Procedure is a sanctions hearing rule where sanctions are presented. Now, we all know that in most cases, evidentiary hearings and sanctions hearings are combined. In other words, they're heard together at the same time. The evidence is presented, and then the case moves on to a sanctions hearing. But in some cases, there is a situation where in a sanctions hearing, it's separate from an evidentiary hearing. Here's what happened in this particular case. In this particular case, there was only a sanctions hearing. How do we know that? Well, consider the evidentiary hearing report, which is Exhibit D to our brief. The evidentiary hearing report says type of hearing, sanctions only. How did we get to a sanctions only hearing? We got to a sanctions only hearing is because the prosecutor for the petitioner commission, in fact, said we have a stipulation as to liability, if you will. We have a stipulation that's been entered. What the stipulation was a Rule 11 agreement signed by Mr. Carrigan's counsel the day before the hearing, or co-counsel the day before the hearing, since he was the lead counsel in that hearing, and which only had one stipulation in it. And that was a stipulation in that Rule 11 hearing that there had been a violation of 5021 and 503A and B1. And that's all there was. There wasn't any facts that were in that Rule 11 agreement. In fact, the Rule 11 agreement was never presented in the sanctions hearing and never presented as evidence. So we get into the sanctions hearing, and we move on to that sanctions hearing, and just to confirm that this was a sanctions hearing and not under 218 and not an evidentiary hearing under 2.17, the chairman of the evidentiary panel, Mr. Chandler, asked the question in the hearing about the scope of the hearing, and it was responded to, the scope of this hearing is a sanctions hearing. So when I read in the Appellee's brief to you that there was an evidentiary hearing, this is a simple case. There was an evidentiary hearing, and in the evidentiary hearing there were facts adduced that are set forth in the judgment, and there's substantial evidence to support those facts. It just doesn't comport with the record. There was no evidentiary hearing. Now,
Mr. Parris, can I stop you for just a second?
Yes, sir, Mr. Kittner.
And see where we are. And when I had read your materials before coming here, I'd like to know what your belief is as to the Rule 11 agreement at this point. I saw things where either it wasn't effective or was Mr. Carrigan was attempting to withdraw it. Can you tell me, as you stand here now, what is your position on the Rule 11 agreement? That's my first question.
My position on the Rule 11 agreement was Mr. Carrigan, remember Mr. Carrigan's co-counsel, his second co-counsel.
It was a lawyer in his office, as I understand it. Is that correct?
Well, I don't know if she was in his office at the time. She had been associated with him. I don't know if at that particular time whether she was actually in his office, but she signed this Rule 11 agreement that had this single law conclusion in it, and it was his intent only to stipulate to, and this comes out in the hearing, in all three hearings, it was his intent to stipulate that there were certain factual allegations in the first amended petition, Mr. Kittner, and that he was stipulating to those to streamline the trial. Now, does the transcript in the sanctions hearing, because that's all we had, say in a couple of places, am I stipulating this rule violation? Yes. It also says that same transcript in the sanctions hearing in at least 3 places, Mr. Carrigan says, I'm not stipulating to misconduct. I'm stipulating to some facts, a certain set of facts, not all of the facts, but a certain set of facts in the plaintiff's original petition. We finally got to the bottom of this when Mr. Chandler, in the motion for stay hearing, and by the way, the panel granted this a stay because they, I think, knew that this was problematic because, and in the motion for stay hearing, Mr. Chandler says, so I think, let's see if I can come up with the page here.
Let me interrupt you or help you.
Yes, sir.
Or both. On page 30 of the first volume of the record, we see Mr. Chandler asking the question, do we or do we not have a stipulation that Mr. Carrigan violated Rule 5.03a and B1? I thought we did, and Mr. Carrigan himself says, based on these facts.
Yeah, and he explains that in the stay hearing where it says, Mr. Chandler says, and this is at page 30 of the stay hearing, what I also hear you saying is when I ask you those questions about stipulation, what you thought in your mind I was asking, because it was a compound question, and I get that, is that you thought I was asking about a stipulation facts, not a stipping of the rules, a stipulation of the violation. Mr. Carrigan answers, that is correct, sir.
Mr. Parris, take those stipulation of facts, are those violation of the rules? Are those a violation of the rules?
No, because what he's stipulating to, or what he's intending to stipulate.
No, what he's stipulated to. He says clearly, these are what I thought I was stipulating to, and he pointed to the parts in the petition. Do those constitute a violation of the rules?
Not in and of themselves, because they are factual allegations of the first amended petition.
But when he stipulates to alleged facts and he agrees that those are the facts, if I don't care how you prove it, other than, if a guy can't admit it, I don't know where you go from that, but he admitted those were true. That taken as so, are those a violation of the rules?
No.
Well, he says that he was approached by a tow truck driver and solicited on behalf of respondent.
The stipulation of the facts, the specific facts.
That is the specific fact.
In the first, that he gave, but there's only 2 or 3 facts that he stipulated to in order to streamline the trial.
But that is one of them. That is one of them. He said 12, 13, and 14, and 13 says he was solicited on behalf of respondent. A tow truck, a guy at the scene at the time personally solicited a party for respondent, and respondent admitted that was true. Is that a violation as a matter of law of Rule 5?
Not of Rule 5.
Well, whatever rule whatever rule you're worried about.
Because, well, that's the only rule that they were trying to.
Why isn't it a violation?
Because Rule 5 has to do with ordered, permitted, or engaged a person to do that, and there was no stipulation to that.
It says he was
won,
solicited
503.
on behalf of respondent. And respondent admitted, he did solicit on my behalf.
No, I don't think that's what he stipulated to, in all due respect, Mr. Gerwitz.
That's what the pleading says, that he agreed to.
You know, if that was stipulated to, then it should have been stipulated to. My point is, in an evidentiary hearing, it was, you can't let the horse out of the barn and retroactively stipulate to something that you didn't stipulate to in an evidentiary hearing that you never even had.
Why do I have to put on evidence if I'm the prosecutor that this guy solicited improperly this business on behalf of this person when that has been admitted, and that's the allegation that he admitted to?
The only thing that you were putting on evidence in, Mr. Gerwitz, in a sanctioned hearing was evidence on the degree of the sanction, not on whether or not the...
So here's the way it goes. You stipulate that you have violated the rule so that there's no need for evidence.
Well...
Wait just a minute, let me finish. You stipulate that you violated the rule so there's no need for evidence. You then call, and other charges are dismissed. You then go to a hearing, and since it's been stipulated, you don't need any evidence. But when evidence comes in by way of stipulation of facts that prove that the rule has been violated, you say that you can't use that because this was announced as only a penalty, a sanction hearing, because you stipulated that he was guilty. But if you put on facts, that's a pretty good deal going that way, isn't it?
For 64 years, the Supreme Court has held in the Burnham versus Heaton case, Mr. Gerwitz, that if there's any question about what you've stipulated to, that even if your lawyer signed it, then the only, in the form of a Rule 11 agreement, then, and that notice is given to the court, and the evidentiary panel is the court, then it's incumbent for them to go back and have a trial on either the whole claim, i.e. the First Amendment petition, or alternatively seek to enforce the stipulation in another trial. Once that notice is brought home to the court, in this case the evidentiary panel, and it was in 3 different hearings, and 2 hearings before even this modified judgment of partially probated suspension was granted. But once that, or signed or entered, but once that notice is brought home, then you can't proceed forward on a consent judgment. This was a consent judgment. If what you've said is correct, and I agree that it's correct, there was a stipulation on supposed liability. There was a stipulation on the rule violation. He says in that hearing, in that sanctions hearing, that wasn't my stipulation. I intended to stipulate certain facts. And so therefore, you've got to go back and try the whole case. Is he willing to give up something to try the whole case on a remand? Sure, because they've got 3 different counts, 2 of which are solicitation, what you're talking about. This was just simply a failure to supervise.
Why do you have to go back and retry the whole case when he stipulated to facts that make him, that support his agreement that he was guilty?
You didn't stipulate to that in an evidentiary hearing, number 1. And number 2, you told the panel that you were only stipulating to certain factual matters in the petition.
We keep going back and forth, and the petition stipulates to the facts that make him guilty. You're saying it doesn't count because this was not called an evidentiary hearing. It was called a punishment hearing.
The rules separate the two, Mr. Gerwitz.
I understand, but you're saying...
I didn't make up the rules.
You're saying that he can stipulate he's guilty and get away with that because it was a statement of law, but if he admits to the facts, he can get away with that if it's a punishment.
I'm not trying to get away with anything. And he's not trying to get away with anything.
Well, I apologize. That's the effect.
It's his position that the stipulation that was signed was meant to be a stipulation on certain facts and not misconduct. And that the prosecutor has to prove misconduct in an evidentiary panel hearing, not a later sanctions hearing. There's a plethora of evidence in this case that this was only a sanctions hearing. The chairman of the panel admitted.
Mr. Parrish, let me ask you just real quickly so I can understand, and I think I understand what Mr. Gerwitz is saying. If they had shown up and said, here is his stipulation, the Rule 11 agreement, and everybody says, yes, it's there, I did sign it, and that was all, would that be enough to support a finding that there was a violation of the rule?
Not if the panel didn't, if one presented to the
Forget
panel.
whether, I'm not asking you whether it was an evidentiary hearing or a sanction hearing.
I know that.
I'm just asking, is that stipulation by itself with nothing more enough for the trier of fact to say that there was a violation of the rule?
No, because it's got to be supported by certain facts. You can't, I just can't come in here, and this has always been the case in these disciplinary matters. You've got to have facts that support the violation. I can't come in here and tell you there's a violation and I may have violated something, but there's got to be a set of facts to support it. That's the reason why this judgment is erroneous.
Well, I think what I hear my learned colleagues saying is if Mr. Carrigan, I know he didn't do it, but if he came in and said, I stole money from a client and signed that, though there were no facts leading up to that, you would say that wouldn't be sufficient?
No, the issue is whether or not he understood what he was stipulating to. The issue is whether or not Mr. Carrigan intended to stipulate to a violation of the rules.
I understand that, but all I'm saying is he did stipulate at least to that those facts occurred, correct?
The lawyer signed a Rule 11 agreement.
He testified to that. He testified that he agreed with these statements.
And he also testified in the same hearing, in the same sanctions hearing, sir, that he intended not to stipulate to a violation of the rules.
No.
But he did clearly testify on the record that he did stipulate to facts. That's not in dispute. He stipulated to facts on the record at the
And he intended
hearing.
to stipulate to certain facts, but that stipulation was never brought forward in an evidentiary hearing because we skipped the evidentiary stage. Now the horse is out of the barn, and they want, in their response, to put the horse back in the barn and say, oh, that was an evidentiary hearing, and there was a stipulation in the evidentiary hearing, and therefore there's sufficient evidence, substantial evidence, if you will, to support this judgment.
So,
that
Mr. Parrish,
doesn't comport with this record.
I'm going back to my question.
Yes, sir.
Assume with me, this just has been discussed here, that this stipulation is in the record, and that's all the evidence. We're in an evidentiary hearing. We do have it where it's clear we're having an evidentiary hearing. The only evidence that's presented is the stipulation. Nobody else presents anything else. At that point, is there sufficient facts, if the trier of facts says this is a violation, to support it? Would you be arguing that's not enough?
If you have an evidentiary hearing, a Rule 2.17L hearing, and there is presented in that hearing
All I'm asking is this stipulation, nothing else.
a stipulation, I would ask the respondent, if you will, to back up that stipulation with facts. Now, isn't it true that based on this stipulation, you're stipulating to 1, 2, 3, 4, and 5, and he would say yes, and he wouldn't say, no, I'm not stipulating the misconduct. He would say yes, and that would be sufficient in an evidentiary hearing.
Your view would be that the stipulation would come in, but until somebody asked him, are these facts
For
you're
facts to
stipulating
support
to,
it.
it doesn't support a violation.
You would confirm that so you'd have facts to put in your judgment to support that violation. You can't move to conclusion of law, which I didn't need to file a motion for new trial, which is another claim I have on. I can attack a conclusion of law, and I can attack a no evidence point without having a motion for new trial up here at this proceeding.
Isn't the purpose of a stipulation to avoid having to prove the fact in some other fashion? Isn't that what a stipulation is?
Yeah, sure.
Well, then
and it's an
isn't that the end
agreement.
of it? Why do you have to have any more evidence than I agree this is true?
Exactly. You have to agree that the factual support for the legal conclusion is true.
And he
And that's-
agreed,
that's what-
he agreed on the record that they were true. He said, I agree that the allegations in 12, 13, and 14, which include the factual allegation that the guy solicited the business for me, I agree that that is true. Now, having agreed that that is true, why do I have to prove it some other way?
Because the conviction, if you will, is not even for solicitation. It's for 5.03A and B1,
Which
which
is?
has to do with encouraging or ordering the non-supervision of an employee. That doesn't have
To
anything to
do
with solicitation.
something that the lawyer cannot do. And what the lawyer cannot do is what was done in number 13.
But that wasn't what he was being prosecuted on the sanctions hearing. He was being the sanctions were solely based on 503A and B1, not 703. That's been dropped from the proceeding. That had been dismissed from the solicitation claim. The 703 claims had been totally dropped from the proceeding.
Because of his stipulation. And now he says, you can't get me on that because I stipulated, which I didn't mean to stipulate to, and so I get to walk around with no problems.
No, he doesn't get to walk around with no problem. They have to have a trial on solicitation, 703, 503, and all the rest of the stuff in their first amended petition in an evidentiary panel, and he's willing to go back and defend that burden on all of their claims.
Mr. Paris, are you are you saying that the issue, because we have the record where he stipulated to facts, and am I understanding you saying the problem is that stipulation occurred in the course of a sanctions hearing and there never was an evidentiary hearing to have
That's
the findings?
correct.
Okay.
That is correct. And I'm also saying that the facts he stipulated to don't form a basis as any evidence for 503A and B1 as opposed to 703 that they dropped. So you didn't even have an evidentiary panel. But the real key to this thing, and I'm going to get out of your way in a minute, or I'll get out of her way. The real key to this thing is the fact that once he notified, and there were 3 different hearings here, but the main hearing was the sanctions hearing. Once he notified the chairman of the evidentiary panel and the members of the evidentiary panel that what he thought he stipulated to was not what was in that Rule 11 agreement, even though that Rule 11 agreement wasn't presented and marked and put in evidence like it should have been. What he thought he stipulated to was different than the single line item in the Rule 11 agreement. That's when they should have stopped everything and said, well, do you want a trial on the whole petition, or do you want us to try to enforce this Rule 11 agreement?
Mr. Paris, I think I understand your distinction, but let me make sure. Is he saying I didn't understand that I was agreeing
To a
violation?
To a misconduct.
Fine, I understand that, but I'm not saying I didn't agree to those facts. In other words, he's not withdrawing his agreement to the set of facts he stipulated to. What he's saying is I didn't understand that by signing that I was also agreeing that those constitute violations. Is that what I'm hearing you say?
What I'm saying is, he says I intended to stipulate some facts.
And did he intend to stipulate to the very facts that he stipulated to?
Well, I don't think it's a proper stipulation in a sanctions hearing. But there were 3 or 4 different sentences in the first amended petition. That's what he said I intended to stipulate to, but I did not stipulate to misconduct.
I completely understand that. All I'm asking at this point for a yes or no, clearly your position is that he did not understand that he was agreeing to a violation. I get that. Second question is he withdrawing his agreement that those facts occurred, whatever you make of those facts? Yes or no?
I don't think that he had an agreement to withdraw. So no, he's not withdrawing something that he didn't make an agreement to stipulate to in an evidentiary hearing. Does that make sense?
No.
Okay. Okay, well, I'm not making sense. Let me try again.
You're saying the stipulation is ineffective because the setting was not an evidentiary hearing, but a sanction hearing. So he could admit all the facts in the world that he wants to, and they are of no consequence because they were in a sanction hearing and not in an evidentiary hearing. That is your argument.
That's one part of my argument, because the purpose of the 2.18 sanctions hearing, which is all he had, is to take evidence on the degree of sanction and not the culpability of the person.
But the hearing was all he had because he had stipulated to the violations, and they didn't need an evidentiary hearing.
Until they got notice that he may have been not stipulating to a violation. When they got that notice, and they got it in this hearing, and they got it in the new trial hearing, and they got it in the stay hearing, that's when they should have backed up and say, wait, we got a problem here. The Supreme Court case or whatever, we cannot enter a judgment a consent judgment based upon somebody that says he's stipulating to something different than we think he stipulated to. And so we got to start again. We got to give an evidentiary panel hearing under 2.17.
So if I go to trial in a case and I've got a stipulation from the other side that says whatever it does, and the other side shows up and says, I'm withdrawing that, even though I signed it yesterday, then...
And you don't have a judgment yet, and that's where Burnham versus Heaton kicks in and says, even if your lawyer signed it, we can't enter consent judgment based on it.
Do you think Burnham and Heaton is still good law?
Absolutely. I do, and it's been for 64 years.
Mr. Paris, can someone waive an evidentiary hearing?
Can you waive an evidentiary hearing? I don't think so, and the reason I don't think so is because in order to get a judgment, you've got to have some factual findings based upon some evidence.
In the form of a stipulation?
Now you can sit there moot, and you can let the prosecutor put on the parameters of a case, the prima facie case, if you will, and let them enter a judgment on it, and I'd say a thing, and I guess you've waived a defensive position. But I don't think you can waive the evidentiary hearing once you've requested it. You can give up and they can take a default judgment, but even in a default judgment setting, the prosecutor would have to come in and put on the parameters to give you a liquidated judgment. I mean, that's where I'm coming from on that.
I understand.
Mr. Paris, let me ask you about this testimony.
Yes, sir.
Mr. Chandler, I think, was on the committee, because I thought we had a stipulation as to misconduct. Do we or do we not have a stipulation that Mr. Carrigan violated Rule 5.03A and B1? I thought we did. Carrigan answered, based on these facts. The question was, so the answer is yes, we do, Mr. Carrigan. For the record, you stipulate you violated 5.03A, 5.03B1 based on the facts alleged in the first amended evidentiary petition at the third cause of action, paragraphs 12, 13, and 14. True? Answer, correct. So whether he intended to stipulate that he violated the rules, he did intend to stipulate to the facts in 12, 13, and 14, which he did admit would be a violation of the rules.
And then he says 3 different times at 3 other places, in conflict with what you just read to me, I'm not stipulating to misconduct.
I understand that. You beat that to death.
And he
But he
explains
admitted that the facts that he agreed to did amount to misconduct. He just wasn't admitting it was misconduct. He was only admitting the facts. And you're saying that doesn't count because it was not an evidentiary hearing. It was a sanction hearing, and the reason it was a sanction hearing was because he had stipulated that he was guilty. So we've got a catch-22, don't we?
There's no catch-22. It's just a remand for a hearing on everything.
On what?
Well,
He's admitted he did it.
He did not admit that he violated a rule.
I'm not asking you that.
Did not admit.
He admitted he did the facts, didn't he?
But those facts have to do with, as you pointed out, have to do with solicitation. He wasn't being prosecuted at that point for
No,
solicitation.
he was being prosecuted. Would you concede that if this fact had been that I solicited this business on my behalf, I solicited, it would be a violation of Rule 7.03? A lawyer cannot do that.
Well,
Is that correct?
that was out of the case.
But is that correct?
A lawyer can't solicit, no.
Would that be
I
a
agree.
violation of 7.03?
Mr. Gerwitz, I agree that a lawyer is prohibited from in-contact solicitation.
Okay, so
Now-
he wasn't, but what he was accused of, because he stipulated, and all those went out of the case based on his stipulation, what he was accused of was letting someone for him make that solicitation that he could not make. Doesn't that make it a violation of 5.03?
No, because 5.03A in and of itself is not a violation. I've tried this in district court before. 503, you have to hook it into 503B, order, permit, or engage a person to do such. There is never stipulation to that. And there was never a stipulation, and there was never a trial, an evidentiary trial on anything, certainly not on solicitation, on 703. So the bottom line to all this is when he told the panel on three different occasions, including in the sanctions hearing, I didn't stipulate to misconduct, a trigger should have gone off. If they want to resue him in an amended petition on enforcement of a Rule 11 agreement, so be it. That's an option they have on a remand. Or they can open the whole thing up and say, we're going to prosecute you on 3 complaints for 703 and 702, 703 and 502B1. He's willing to take that burden. I'm sorry I ran over.
That's,
Terribly out of line if I said so.
it would at this point. I'm sorry, Mr. Carrigan. Why don't you take a minute, because I know you had a lot of questions, to wrap up this portion, and then I'm going to call on Ms. Hamilton.
Well, I think I've stated everything I needed to state. I mean, one of the other sections of her response brief was that this wasn't raised properly in a motion for new trial. I think I touched on that already. Since there's no evidence to support the fact findings in the judgment based upon a Rule 2.17 evidentiary hearing, then that doesn't need to be brought forth in a new trial as a predicate for me being here today. Secondly, a question as to whether or not a legal stipulation is in effect doesn't. I don't have to file a motion for a new trial to bring that forward here today. That's a law question. So that was another section of their brief. But basically, they want, as I said, they want to paint this as a simple evidentiary trial in which facts were stipulated to, and that those facts are in the judgment, and therefore there's substantial evidence. This just does not comport with the record. There was never even an evidentiary trial.
Thank you, Mr. Paris. Ms. Hamilton.
May it please the board. Good morning.
Morning.
The issues that are being argued by Mr. Carrigan in this appeal have no merit because it is clear from the record that he agreed to 3 things. 1, he agreed to stipulate to facts that were sufficient to constitute misconduct under 2 provisions of the rules. And 2, he agreed to waive his opportunity for an evidentiary hearing regarding misconduct. And 3, he agreed to proceed directly to a hearing on sanctions only.
Ms. Hamilton, before you get into your argument, what do you say in response to his argument that as soon as he made it known that there was some question as to what he was stipulating to, that there was an obligation on the part of the panel to stop it and start anew?
And hasn't he already waived that by entering into the stipulation?
Yes. The simple answer to that question, Mr. Black, is yes. And in response to your question, Mr. Kittner, there is simply no support in the record for Mr. Carrigan's claim that the panel was aware or should have been aware that there was any question about his stipulations.
Let me just ask you, just as a legal proposition, if there had been sufficient facts to put the panel on notice that perhaps there was some question as to stipulation. Do you agree with Mr. Paris's assertion that the panel had an obligation at that point to stop and start over?
Yes, if there was some question, but based on this record, this panel did an excellent job of making sure that the record does not show some uncertainty regarding consent. Both Mr. Carrigan and the lawyer who was representing him, they said otherwise multiple times on the record. Now, starting with the written stipulations, which specifically state that he is stipulating to facts sufficient to admit that a violation occurred under the two rules that are at issue here. So we have that in writing. It's in the record and it's attached to the commission's brief. In addition to that, during the hearing itself, this sanctions hearing, there were multiple exchanges on the record regarding the stipulations and the nature of those stipulations and exactly what they encompassed. A lot of those are set forth in the commission's brief. Anytime there was any hint from Mr. Carrigan, anytime he veered off track with regard to the stipulations, the panel stopped and confirmed that he was actually stipulating to the facts in paragraphs 12, 13, and 14, and he was stipulating that he violated the two rules in question. The panel took great care to ensure that was clearly understood, that it was on the record. As I said, there are multiple quotes in the commission's brief, but in addition to that, a quote that's not in the commission's brief happened sort of late in this evidentiary hearing, and it was an evidentiary hearing, it just had to do with sanctions, just not on misconduct. But in this hearing, Mr. Carrigan began testifying about some of the facts in the two grievances that had been dropped, that the commission had agreed to drop in this case. And one of the panel members, Mr. Trachtenberg, urged Mr. Carrigan to stop talking about those facts. And he said that because those complaints aren't being heard, you shouldn't be talking about the facts. And he said, and I'm going to quote what Mr. Trachtenberg said, he said, "You want to undo it? We can undo it." Clearly talking about this agreement between the commission and between Mr. Carrigan. And Mr. Carrigan responded by saying, "I'm sorry," and thereby confirming that he wished to proceed as he had agreed. Again, according to these stipulations and his agreement to waive his right to a hearing regarding misconduct and proceed directly to a sanctions hearing. That's exactly what happened here. And I think it's important to consider exactly what transpired. I mean, we're talking about the eve of the hearing, the night before the hearing took place. Mr. Carrigan's lawyer and the commission's lawyer talk about the case. They agree that the commission will drop 2 of the 3 grievances that were set to be heard the next day by the panel. The commission agrees to drop 13 of the 15 alleged violations that are set to be heard by the panel the next day. So the commission has essentially agreed to drop the bulk of its case in exchange for Mr. Carrigan's agreement. So the commission gave up a lot here. Get to the hearing, the parties go into the hearing, they confirm on the record that they have this agreement, it's discussed at length, there's no question as to what the contents of the agreement are. So the hearing closes, there's no request that the panel chair asks Mr. Carrigan's lawyer if he has anything else he wishes to present. They confirm that no, they've offered everything they had to offer. The hearing closes, the panel enters judgment. I suspect that Mr. Carrigan was surprised by the sanction that was entered in light of the fact that on the record he urged the panel to impose a private reprimand. The judgment is entered. Mr. Carrigan files a motion for new trial. Even in that motion for new trial that he filed, he didn't complain, he didn't say anything about the stipulations. He raised 2 issues. He complained about some hearsay evidence that was entered into the record for the sanctions hearing, and he complained about some provisions in the judgment regarding some of the sanctions. He thought that those went a little too far. He didn't say anything about the stipulations, never questioned them, never said I didn't intend to stipulate to those things. It wasn't until the hearing on his motion for new trial that that issue was raised for the first time, and it was too late to do that. Mr. Carrigan had waived this issue by that point, and he had not only waived the issue, but he hadn't inadvertently waived the issue. He had affirmatively agreed that this was the way he wanted the case to proceed.
Ms. Hamilton, is there anything in the record that indicates that Mr. Carrigan's counsel did not have authority to enter into those stipulations on his behalf?
Nothing in the record to indicate that. That was never raised with the panel.
Ms. Hamilton, you said that, if I understood you correctly, that his stipulation to the facts was attached to your brief. Can you tell me where that, I see the Rule 11 agreement dated April 11th, 2013 that stipulates to professional misconduct, but I'm not seeing a stipulation to the facts underlying the misconduct.
Those are the only written stipulations, is that document, that letter that's attached to the commission's brief that you just identified. And it says that the parties stipulate that Mr. Carrigan engaged in professional misconduct in violation of the two rules at issue, 503A and 503B1. At the hearing, when the parties arrived the next day, that's when a discussion ensued about exactly what these written stipulations meant. Here today, Mr. Carrigan is questioning exactly what it says in this letter. He's saying he never intended to make the stipulations that are explicitly set forth in this letter. He admits he intended to stipulate to the facts set forth in paragraphs 12, 13, and 14 of the petition, as he stated on the record at the hearing. So these are the written stipulations, and then they were fleshed out, and there's a very clear record of exactly what the parties intended from the record of the evidentiary hearing.
Ms. Hamilton, you indicated that the commission gave up 2 of the 3 claims that had been filed in exchange for this agreement. Is that correct?
That's correct.
Mr. Paris has said, in effect, I think, I may be misunderstanding that let's just start all over again. And if you start all over again, I assume the 2 that the commission has given up on go back in the hopper. Would that be correct?
That's
and
correct.
if it goes back to the panel, could the sanction be greater than the one they've already given?
Well, of course. As I pointed out, the commission agreed to drop, the vast majority of the allegations that were pending. So absolutely.
So if Mr. Paris is successful in what he's asking for, that is, he gets a remand and a new trial, so to speak, it's just starting anew, and Mr. Carrigan would be subject to the 3 grievances that were previously filed and whatever penalties, greater or lesser, that the panel chose to impose. Is that correct?
That is correct.
Okay, thank you.
That is correct, which, sounds on its face like maybe it's a pretty good deal for the commission. But actually, when you think about the resources that have gone into this case already, and thinking about starting from scratch and going back to the panel for a new hearing, it's such a tremendous waste of resources. And Mr. Carrigan, in urging the board to send us back to the panel, is really asking the board to accept what is an untenable proposition, that we can have parties in an uncontested case that walk in and tell the tribunal that they don't wish to contest anything, they want to move straight to phase 2 of the case. But Mr. Carrigan is here telling the board that the parties can't do that, and that the panel has to force the parties to try facts that are essentially not in dispute. That's just an unreasonable proposition.
If you were being totally objective, not being an advocate for one side or the other, would you say that there is any evidence in the record of his equivocation on the stipulation? You've told us as an advocate he did not. I understand that, and I appreciate that. I'm asking you now, is there anything that someone could look at and say, well, maybe there is?
If you look at the record as a whole, no, you cannot draw that conclusion. And I think the most telling aspect of the record is that motion for new trial. He didn't even mention it there. Every time, there is, during the hearing, there are times where Mr. Carrigan says some things that are unclear, excuse me, and cause the panel to want to confirm multiple times exactly what the substance of the parties' agreement is, to make sure that they didn't misunderstand what the terms were. Admittedly, the letter that was signed didn't flesh out every term of the parties' agreement, didn't describe every term, so it had to be fleshed out at the hearing. But multiple times the panel went through, discussed in detail with Mr. Carrigan what his agreement was, and each time the exchange concluded the same way, and that was with Mr. Carrigan confirming that he stipulated to the facts, and he was stipulating that those facts constituted misconduct under the rules at issue. So you just cannot, you cannot objectively reach that conclusion.
Ms. Hamilton, what's our standard of review?
If we're looking at, so it depends on how you look at the case. Now, if you break this case down to its essence, and if we accept that everything Mr. Carrigan says is true, that there is some reason that for the panel to have questioned his stipulations and his consent to what happened here, then what the board would have to ask is, do the stipulations of fact that he still agrees he made, he's not withdrawn those, he says I did stipulate to those facts, do those facts provide more than a scintilla of evidence for the conclusion that he violated the rules at issue? Those stipulated facts do provide a reasonable basis. They provide more than a scintilla of evidence for the violations that were found by the panel. And for that reason, the judgment should still be affirmed. Now, of course, the commission says that the board doesn't even have to get there because the other arguments are so clearly refuted by the record. But even if we accept exactly what he's saying, we're still okay, and this judgment should still be affirmed because it is supported by the stipulated facts.
What about the fact that his argument is because those, if I understand the argument correctly, or just assume the argument is because those stipulated facts came in a sanctions hearing and not in a hearing on misconduct, that they cannot be more than a scintilla of evidence as to a misconduct violation. What's your response to that?
I think I have a two-part response to that. The first is I see absolutely no merit to that argument because he waived his opportunity for an evidentiary hearing on the question of misconduct. And the second part of my response is there really a difference? The parties came before the evidentiary panel on the date set for the evidentiary hearing on both misconduct and sanctions and announced their agreement there, announced their stipulations, got those into the record, and then the actual sanctions, the evidence on sanctions and the sanctions portion of the case, that hearing began. So there's really not a difference here. There was a hearing called on the date that had been noticed as an evidentiary hearing for whatever matters needed to be heard that day. So I think that's really just a hollow argument.
Did he waive an evidentiary hearing, or did he agree that his stipulation as to facts could be considered at this hearing, whether you called it evidentiary or sanctions?
I think both. Both. If you look at the letter that sets forth the parties' agreement, it says not only does he agree to stipulate to the two rules, but it also says that the evidentiary panel will conduct a hearing to determine the appropriate disciplinary sanction for his violation of the above stipulated rule. And evidence and/or testimony may be presented for the panel's consideration in rendering an appropriate disciplinary sanction. So it was clear that he was giving up his opportunity for a hearing on misconduct. And not only does it say so in that letter that the parties signed the night before the hearing, but when they arrived that day, they announced their intent to waive an evidentiary hearing with regard to misconduct. And in conclusion, the board should affirm this judgment because the party stipulations, which are both in writing and clearly stated and discussed on the record, they provide sufficient support for the judgment. That's the bottom line here, and the commission urges the board to affirm the judgment. Thank you.
Any questions, other questions of Ms. Hamilton? Okay, Mr.
Will you give me
Pierce.
time for
Absolutely.
a couple of brief comments?
Yes, go ahead and take your 4 minutes.
Thank you. Real quick, page 17 of the hearing, Mr. Carrigan says, I'm not stipulating to any facts that this was or that there was. Page 28, I agree 12, 13, and 14 they claimed happened. Page 29 of the sanctions hearing, I'm stipulating to those facts. I'm not necessarily stipulating to misconduct, but I'm not stipulating to that constitutes misconduct. I'm not stipulating anything there is wrong. And just to make the record clear, what he was stipulating to, the underlying facts were that the potential client called my employee from the scene. The potential client was told must come to my office. The potential client came to my office, and that he was not stipulating that those facts in that petition was a violation. And he said he had a problem with that being solicitation, and that he wasn't stipulating that that was misconduct. So those are the facts that he says that he's stipulating to. And in answer to Mr. Kittner, I believe's question, there is an abundance in this record in the sanctions hearing, not the two subsequent hearings, that as to what he claimed he was stipulating to, and that it wasn't misconduct. And so, yes, there's indications there in several different places, and I re-quoted that in the.
I understand that, and Ms. Hamilton's response was every time that occurred, that the panel was careful to say, hold on a second, let's make sure, and that they satisfied themselves. Is that not sufficient?
Well, Mr. Singal says, here's how he satisfied himself, which is his understanding, and I'll see if I can locate it here real quickly. Mr. Singal, I think my understanding is that we tried the case only on damages or sanctions, basically. We did not obviously decide the merits of the stipulation as such. We basically took it at its face value. That's what's written here, and what Mr. Carrigan testified, that even if the stipulation is very clear as to the matter of the CHOPA and the matters that the parties stipulate that Stephen Carrigan engaged in professional misconduct in violation of the Texas rules. So I think this committee basically decided on sanctions solely based upon that understanding that he had admitted to the violation of this rule. And that I think is just This confusion seems because if we had known that there was some limited stipulation or of stipulation, some technical stipulation related only to certain facts but not misconduct, then obviously we did not fairly consider all of this.
Now that's after the hearing, right? Hold on, that's after the hearing and after he's gotten the sanction instead of the private reprimand that he's hoping to get. Isn't that all correct?
Well, that's after the judgment. That's after the modified judgment was entered.
Right.
Mr. Singal says, "Here's what I was thinking back at that time."
Right.
And so he's relating to what he was thinking during what he was considering during the sanctions hearing. And I don't think you can, from the standpoint of waiver, I know there's been some back and forth about waiver. I don't think you can waiver into a consent judgment when there's any question about whether or not you consent to certain matters. The other thing is that, again, the items in the stipulation, the items in the petition, our position does not give rise to any in answer to Mr. Gerwitz, does not give rise to any violation for solicitation. So if you go back and you take those paragraphs of that petition, Mr. Carrigan just reminded me to remind members of this, that doesn't give rise to violation. Thank you.
Thank you, Mr. Paris. We will take your arguments under advisement and advise you of our decision.
Thank you.
Thank you.